versus Rambo L, file numbers 22L2761882, 881, and 883. Council appearance, please.
Matt Staples on behalf of the City of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe
Okay.
Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th is when it went unanswered. I would like the court to dismiss this matter.
Before we even get into courtroom chaos you're about to witness, let's take a second to set the stage, because this is one of those sovereign citizen cases where confidence is high, paperwork is imaginary, and reality refuses to cooperate. What you're about to see isn't just a misunderstanding of the law. It's a full-blown collision between legal fantasy and courtroom procedure. We have a defendant who insists he's appearing by special appearance, believes traffic laws don't apply to him, and thinks citing obscure documents or even scripture is somehow a legal cheat.
Motion for challenge of jurisdiction that I submitted to the clerk. And I've served everybody, all parties. How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom. Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court. Neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied. Is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James version, Luke 11:52, as well as some other.
This moment right here is where the sovereign citizen narrative quietly collapses before it even gets off the ground. The prosecution confirms that the defendant has a valid driver's license, which is critical because it directly contradicts the entire right to travel argument he's leaning on. You can't claim you're not subject to driving laws while simultaneously holding and presenting a state-issued license. Those two positions cannot exist at the same time. And notice how the court doesn't argue or mock him here. It simply proceeds forward, calmly acknowledging the facts. This is something judges do exceptionally well. They let the record speak for itself.
As indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will
Well,
set your matter.
I like to challenge jurisdiction right now. I have the right to
You can file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible, okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just, we don't have it. I don't know why we only have one motion, that we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm gonna set both of these matters for hearing though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're gonna file it in writing and you're gonna serve it properly on the parties that you're filing it against, okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records,
Oh,
please?
you want to call him? Let me.
Oh, I'm sorry.
Swear, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Here's where we start seeing a pattern that shows up in almost every sovereign citizen case. Motions that sound official are titled dramatically, but legally mean nothing. The defendant insists he filed multiple motions challenging jurisdiction, yet the court can only see one, and even that one doesn't meet basic filing standards. Courts don't operate on vibes or intentions. They operate on what is properly filed and served. Saying "I sent it" is enough. And when the judge starts explaining the difference between a notice and an actual motion, you can hear the patience in her voice. This isn't a shutdown, it's a lesson. Unfortunately, the defendant doesn't absorb it.
So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour and it caused me to be late for my son's banquet.
This is the point where things veer from misguided into outright surreal. When the prosecution explains that the defendant's filing cites Bible verses from the King James Version, it perfectly captures a core issue. This defendant is operating under an entirely different belief system than the legal one governing the courtroom. Courts don't reject arguments because they're strange. They reject them because they don't comply with procedural law. Jurisdiction isn't challenged through scripture, personal philosophy, or online templates. It's challenged through specific motions, filed correctly, under court rules.
And I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. Earl, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
Yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence because when you file a motion, you got to get a hearing date for that motion. And so
who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And asked for
And I
hearing
asked
dates
them,
for your
and
motion?
I asked when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they
But-
said
And you do have a hearing date, but that's not what I asked you. Did you ask them?
they didn't tell me, but I did provide to him an order for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a copy. You can make it now orally.
Okay, well, now comes the beneficiary for Rambo L, defendant in error here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer Zenderbarth. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff lacks jurisdiction, personal firm jurisdiction. Christina Simmons being appointed as trustee, the prosecutor is being appointed as co-trustee. I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because I've done a name change.
When a judge explains that jurisdiction cannot be challenged verbally and must be done through proper written motion, this is a critical teaching moment, not just for the defendant, but for anyone watching. Courts are structured environments. They rely on documentation, timelines, and service requirements to function fairly. The defendant keeps insisting on his right to challenge jurisdiction immediately, but rights don't override procedure. This is where many pro-se litigants fail, not because they're denied access, but because they refuse to engage with the system as it exists.
The United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785, we find United States government as a foreign corporations with respect to the states. Since the corporation is fictitious, is a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, allegiance, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, and effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons, things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. People, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling in my private property. Here are some examples of my Supreme Court constitutional defenses. Number 1, case number 1, the right to travel is part of a liberty where a citizen cannot be deprived of due process under the Fifth Amendment, Kent versus Duels, 357 U.S. 116, 125.
This exchange of the officer is where the emotional argument completely backfires. The defendant claims he was detained too long and missed his son's banquet, but then admits the delay was caused by his own insistence on waiting for a supervisor. That's not police misconduct. That's the natural consequence of refusing to cooperate. Courts care deeply about timelines, but they care even more about causation. If your actions prolong a stop, you don't get to assign blame afterward. The officer's testimony is calm, consistent, and supported by the record. And once again, the sovereign narrative fails under basic scrutiny. Emotion without accountability doesn't move a case forward. It undermines it.
Pursuant to Shapiro versus Thomas, 394 U.S.P. 618. That right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously converted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything, says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with a community. Case number 5, Marbury versus Madison, 5 U.S. 137 shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262 says I may ignore the license and the fee and engage with the right with the immunity. That means you can't punish me. And United States versus Bishop defines willfulness as an evil motive or intent to avoid a known duty, task under the law with a morality certain. I submit I couldn't have been doing an evil task. I totally followed the Constitution in the Supreme Court. Bryers versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in the favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respect to those who were designated to safeguard the liberty and security of a citizen in regards to both persons and property. See note 31, Bryers versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial.
This is one of the most important moments in the entire case. The judge explains, clearly and patiently, why filing motions isn't as simple as submitting paperwork. You must request a hearing date, serve all parties, and follow court rules. This is exactly why self-representation is so risky. The court even bends over backward to hear the motion anyway, despite it being improperly filed. That's judicial discretion at its finest. But here's the irony. Even with all that leniency, the outcome isn't going to change because flawed arguments don't become valid just because the court...
Injury nor trespasses, any trespasses. All crimes are commercial, 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted by the name of the people of the state. I don't have a contract with the state.
Any additional argument on your motion?
I would ask the court to dismiss this to failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city. Your claims would be most appropriately brought before the Court of Claims, and so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as it relates to your civil infractions, you have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK, Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compiled laws. Here in this district court, we are subject to the Michigan court rules. And so although I gave leniency with your motion, it was not properly filed and or served. But it also does not comport with the Michigan compiled laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we do not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place.
At the end of the day, this case perfectly illustrates what happens when ideology collides with law. The judge maintained control, followed procedure, and allowed the defendant every reasonable opportunity to be heard, while still enforcing the rules that keep the court functioning. The defendant's arguments failed not because the system was unfair, but because they were built on misunderstandings, contradictions, and legally meaningless filings. Sovereign citizen theories may sound empowering online, but inside a courtroom, only facts, rules, and proper procedure matter.